So that then seems to give us a kind of a set of principles to consider, in any case involving judicial review of executive power. Well, does it concern something that calls for broader political judgment? Does it involve a provision of the Constitution that restricts or constrains government in the exercise of its powers in some specific way that might call for a forensic determination by a court, or does it not? And does it concern or involve an arguable breach of rights? Because if it concerns an arguable breach of rights, well then the regular standard of review would apply, the same standard that is as would apply in the case of legislation, for instance, that was said to breach constitutional rights. So in other words, a regular proportionality framework would apply. So where does that leave TD then? Now, what's interesting is TD gets very little attention. It's mentioned twice, I think, given a line, perhaps 2 lines on each occasion. That is in the O'Donnell judgment in Elijah Burke. Whereas, Crotty and Boland, for example, get lots and lots of attention, especially Boland. And I think I can see why, because Crotty or Boland, I'm assuming knowledge of those cases again, there was no obvious, in fact, it's hard to see how you could say that constitutional rights were engaged in those cases. They really were structures cases. Did the government have the authority to ratify Title III as an ordinary exercise of executive power? Ray Crotty argued no. And Ray Crotty's rights weren't engaged in any way. So it really was a kind of a structures or a classic separation of powers case. And O'Donnell says, well, that fundamentally is why the clear disregard standard applied in that case. TD seems to straddle the divide a little bit, right? It seems to, it clearly involves arguable breaches of rights. Right? In fact, the rights question wasn't contested, I don't think, before the Supreme Court in TD, but it also has to do with separation of powers and whether the courts had the authority to hand down a mandatory order of the kind that it did in the case. Again, I'm assuming knowledge of the TD case. Now, if you look at the judgments in TD and the Minister for Education, I suggest in particular that you look at the Chief Justice at the time, Ronan Keane's judgment. And Mr. Justice John Murray's judgment. John Murray's judgment is actually quite short. So is Keane's quite short. If you look at them, what's striking about the appeal to the Supreme Court is that the case really was about the mandatory order, the order that had been handed down by the President of the High Court in February of 2000. Now, what I'm suggesting is that actually, if you look at the TD judgments, like I said, if you look at Ronan Keane's judgment, the Chief Justice, or John Murray's judgment, for example, in Ronan Keane's judgment, the clear disregard phrase doesn't appear anywhere at all, if I'm not mistaken, in the 83 paragraphs. Nor does the concept of deference actually appear in Ronan Keane's judgment. Similarly, in John Murray's judgment, clear disregard appears once in 1 paragraph out of, I think, 53 paragraphs. It's at the very tail end, and it's clear from the reasoning that he has already reasoned his way to his conclusion independently of clear disregard. And again, there's no reference in the main reasoning to deference, the concept. And the same is true of the more flamboyant judgment of Adrian Hardiman. How does Keane decide it? How does the court decide it? Well, really, it seems to me by emphasizing that distinction between interference with the government in the exercise of its executive power, on the one hand, and actual taking command over and exercising that power yourself. Right? What I mean by that is Ronan Keane says in his judgment, paragraphs 75 to 79, all because the government under the Constitution has exclusive authority to exercise executive power does not mean that the courts can't intervene. The courts can intervene, right? But he says this isn't a case like that. That's not what's at issue in this case. What's at issue in this case, essentially, he says, is whether or not the President of the High Court had the authority to actually actively take command over and exercise executive power. And Ronan Keane says, no, the Supreme Court, the High Court judge didn't have that authority. So would TD be decided any differently today in the light of the Elijah Burke case, or does anything in the Elijah Burke case suggest to us that the modern court the O'Donnell court, let's say, might be open to finding in favour of an applicant like the applicants in TD. I would say I don't think so. I don't think the O'Donnell court would hesitate at all. In fact, I don't think that the Ronan Keane court would have hesitated at all about making a declaration, right, that the government was acting in breach of the constitutional rights of the applicants in TD. Really, I stress that such a critical part of the Supreme Court reasoning was that distinction between declaration and mandatory order, and not only that, but mandatory order that specified in detail, here's how you've got to do it, effectively exercising executive power. I can't see the O'Donnell court happily endorsing that ruling, if you like, that is to say the Peter Kelly ruling in the High Court. I do think that if you look at that paragraph 61 of the Elijah Burke case, you find O'Donnell saying, his principle, he says, in rights cases, there's no justification for applying a different standard of review depending on what organ of state has breached the rights, which is maybe very promising if you're somebody who is skeptical of TD. But he says, there's nothing to suggest that the judgment is political in nature in rights cases, or that the Dáil has a particular expertise in the areas, so that accountability of the government to the Dáil should be seen as the primary or sole method, right? In other words, unlike in those cases like Crotty, or let's say McKenna, or Boland, where, there were good reasons as to why, you might say the Dáil was the chief mode, or the maybe primary mode of accountability for the government, thereby reinforcing the clear disregard test. But I think there's an awful lot to suggest, there's an awful lot in TD to suggest, that the judgment was political in nature. That is to say, the judgment precisely as to how, what units to open and build in what parts of the country, and how to staff them, and how to resource them, and so on. They are very political questions. And there are very good reasons as to why we would think that the Dáil is the primary agent, right, for holding the government to account under the Constitution for how it does that work. And if the government can say, right, in the Dáil, well, we're bound by the terms of a High Court order, so you can't hold us to account, you got to hold the court to account. That messes with the constitutional structure, and it seems to, if you like, give credence to the notion suggested in the O'Donnell judgment that TD, notwithstanding that it has to do with constitutional rights, is fundamentally, certainly at the Supreme Court level, right, when the case came to be about the mandatory order and its terms, right, the case is better understood, I think, as fundamentally a separation of powers case, and was decided on the basis of the separation of powers. Now, I should point out, incidentally, I tend to agree more with what Denham says about the separation of powers generally in her dissenting judgment than, the rigidity that Hardiman and Murray talk about in their judgments. But on the actual ruling, and the reasoning for the ruling, right, the terms of the order, the actual taking command of and exercising executive power, and so on, I have to say I'm very sympathetic to the position taken by Ronan Keane in particular, and John Murray. But there it is. So we do understand, I think, judicial review of executive power much more now after the Elijah Burke decision than we did previously.